Madam William C. Sheridan.
Mr. Sheridan, good morning. You may proceed. I beg your pardon?
I didn't know the protocol.
No, you may just proceed right ahead.
Okay.
Good morning,
Thank
Mr. Sheridan.
Morning. Thank you very much for hearing my appeal from the the single justice's decision. In this case, it involves two orders. I was suspended for 1 year involving a New Hampshire bankruptcy court order, and that New Hampshire bankruptcy court order was through reciprocal discipline imposed in Massachusetts in March of 2002. Subsequently, that underlying New Hampshire bankruptcy court order was vacated by the First Circuit Court of Appeals as unconstitutional in that it had been issued without authority, jurisdictional, and had denied me my right to an Article III court's determination, a matter that the federal judiciary holds dear, and in that it is their scope of power. Subsequently, I was also suspended for 1 year from the New Hampshire Supreme Court, and I didn't notify this court of that proceeding, but I never objected to it. Just so the court knows, I had just recently on Friday received an order from the New Hampshire Professional Conduct Committee recommending that I be reinstated in New Hampshire, subject to a mentoring agreement for 2 years with 3 individuals that I've already worked out a deal with. And then last year, an order was issued by the single justice in Massachusetts suspending me under reciprocal discipline under that New Hampshire case for 1 year and a day. And also, at the same time, I had made a motion to vacate the original Massachusetts reciprocal order that was premised on the bankruptcy court's disciplinary decision, and that remains outstanding with no decision on it. So right now, I'm suspended under the March 2001 order of reciprocal discipline based on the New Hampshire Bankruptcy Court order, and suspended for 1 year and a day under reciprocal discipline under the New Hampshire Supreme Court order that's unrelated to the bankruptcy court order. As I perceive it, there are 3 issues. The first issue is whether that first reciprocal order issued by this court in 2002 should be vacated. And it should be, I think the case law is abundantly clear that when...
Is that before us right now, that particular request? Or is that before the board or the single justice?
The single justice has not acted on it.
The petition is before the single justice?
There's a motion to vacate
Okay.
that, and the single justice has not acted on it. And it's almost
Shouldn't
a
we
year
wait
has
to see
passed.
how he acts?
Well, it combines quite a bit, because it also, by leaving it outstanding, it almost creates an argument to say that now this court can rely upon those bankruptcy court findings when I would argue it can't.
Did the single justice rely upon the bankruptcy court decision in ordering the 1 year and a day suspension?
I believe that the single justice clearly drew negative inferences in his opinion.
Was it from the failure to notify the Board of Bar Overseers?
No, that the negative inferences that are drawn were, one, that I had shown lack of diligence, and two, to say that there had been something like 88 violations of the Code of Ethics. And those are two substantive findings of fact. And I would argue that if, in fact, they were not relevant to the court's later statement that we're dealing with repeated acts of misconduct, then they should never have been mentioned in the order.
Was the lack of diligence related to the bankruptcy matter or to your failure to notify Massachusetts about the second New Hampshire, by the judgment by the New Hampshire Supreme Court?
My recollection was that the court's statement of lack of diligence applied solely to the findings of the vacated unconstitutional bankruptcy court order. I would stipulate and agree that I didn't timely notify this court of the New Hampshire suspension. Incorrectly, that was a poor error of judgment on my part. In my own mind, what I'm thinking is that I'm already suspended under the bankruptcy court order. My particular life had completely fallen apart, and I was spending every single inch and energy of my time to try to put my life back together again before I wanted to add that extra burden. And it's an enormous amount of work. You know, once you notify the court, it's a lot that you have to do. And I wanted to get a job, and I wanted to get my mortgage solvent and stable, and I wanted to get my family solvent and stable first. That was my own judgment, and I agree that I violated my duty to the court. But I would argue that there were mitigating circumstances, and I would also argue that there was no harm. It's not like the other cases where a person is suspended in Vermont and is continuing to have a license to practice law in Massachusetts and doesn't notify this court. They still have the right to practice in this court. And by not notifying the court, they're taking advantage of something. I didn't have the right to practice. I wasn't taking advantage of anything. Error of judgment, I agree. Lack of following my obligations to the court, I would agree. But I would think mitigating circumstances with no harm. I was suspended. I remain suspended by failing to notify the court. In no way did I create any harm to the public. But I believe that this whole idea of this bankruptcy, just back up for a second. The real irony of this case, I believe, is that what we're all being asked to do procedurally is pick and choose which final orders we want to enforce. And Bar Counsel is arguing that you look at only select orders. I think you have to look at the final order in that bankruptcy matter. That final order said that the findings were vacated, that they were unconstitutional, that they really were an infringement upon the very essence of an Article III court and the powers of an Article III court. And those powers, just like the powers of this court, go to the very essence of due process. And I believe very firmly that when the First Circuit vacates an order, that decision demands and deserves respect at every level forthwith.
When did the First Circuit's decision come down?
In March of 2004.
And when did you file your motion to vacate the discipline here?
During these proceedings.
Well, do you remember the date of the motion that you filed?
I filed it the day. I filed it the day of of what turned out to be a hearing, but what I thought was going to be a structuring conference. I received a call.
Remember the date?
I don't remember the exact date.
Was it soon after the First Circuit decision?
No, it wasn't.
Was it more than a year after the First Circuit decision?
It was, I think, 2 years after the First Circuit decision. And again, It's because I was focusing on building my life. But the cases are quite clear that when you're dealing with a constitutionally infirm decision that is premised on jurisdictional grounds, that any decision that relies on it, such as this court's reciprocal order, is likewise constitutionally infirm and should be vacated forthwith, regardless of the time frame that the motion to vacate is brought. I guess my time's passed.
Thank you, Mr. Sheridan. Ms. Kaufman?
Thank you, Your Honor. May it please the Court, Nancy Kaufman for Bar Counsel. The first question, the first issue is whether the year and a day is appropriate discipline for the conduct in New Hampshire. The single justice made it quite clear in his decision and in his amended decision that he was not relying in any way on the bankruptcy court matter in deciding that a year and a day was appropriate. He was relying on 2 public reprimands and 2 orders of suspension in New Hampshire within the space of 4 years. And recently this court had a similar matter before it in matter of Steinberg, where there were successive 60-day suspensions ordered, and the single justice ordered a year and a day, and that was found to be appropriate. There's nothing different about this case. It's not markedly disparate from other sanctions, and the single justice did not abuse his discretion in ordering it. The second issue is whether or not Mr. Mr. Sheridan should get retroactivity. And what he is trying to do is actually what he is accusing Bar Counsel of doing, which is picking and choosing among the various orders. He would like to substitute the suspension that he now says is void.
Well, that's like getting a coupon
Exactly.
to commit
He'd like
malpractice.
yes, he feels that he could actually use that to satisfy this term of suspension. But if the court were to do that, it would totally undermine its rule that requires lawyers to report within 10 days any sanction, any public sanction, including the 2 public reprimands and the 2 orders of suspension, to this court.
Now, one of those 2 orders of suspension was the bankruptcy.
No, I'm only talking now about the orders that were entered by the New Hampshire Supreme Court. None of those had anything to do with the bankruptcy court order. There were 2 orders of suspension in New Hampshire, preceded by 2 orders of public reprimand, all of which Mr. Sheridan was required to report to the Office of Bar
And
Counsel.
did any of those arise out of the bankruptcy proceedings?
No, they had
None.
nothing to
Okay.
do with the bankruptcy court decision, not at all. But he did not report that, and that had to have been deliberate, as he concedes here today, because in connection with the reciprocal discipline proceeding arising from the bankruptcy court decision, he was found to have violated the rule that requires reporting. So he knew about the rule.
I thought the 2 of us asked questions to the effect that did the single justice rely in any respect on the bankruptcy court
He did not.
disciplining?
He says, the single justice says in a footnote, I do not in any respect rely on the bankruptcy court decision.
So in imposing the 1 year and a day discipline in the new case,
Right.
it was writing on a clean slate.
Right. Now, he did say that a reinstatement proceeding in Massachusetts was required, and he did take into account the fact that it took the respondent more than 2 years to file a motion to vacate the suspension that had arisen out of the bankruptcy court case. And that indicated that his problems with organization and attending to legal matters was not behind him. A fair remark. Now, I do think, although it wasn't actually clearly argued, I would say, in the respondent's brief, that it would be fair to the respondent for this court to make a decision about this bankruptcy court suspension.
Can we make that decision, or does that's a motion that was filed on this before the single justice. The single justice hasn't addressed that motion.
That's
correct?
true. That is true, and it
So
could...
on what conceivable grounds can we
It's been
reach
pending
down?
for more than a year, and it was actually filed in connection with
It
this
was
case.
filed, yes, it was filed back in June of 2006. It was filed on the day we actually had the hearing on the reciprocal discipline motion arising out of the New Hampshire proceedings. It was filed that morning.
So
And
you're not opposed to the
opposed-
relief he's asking for?
I'm not opposed...
On
to-
that piece?
I'm not opposed to the court deciding that issue. I have briefed it. I've tried to collect all the authorities that I could find, and there aren't a lot, because this is not the same kind of case. This isn't a case where the bankruptcy court lacked subject matter jurisdiction, and it's not a case where the bankruptcy court lacked personal jurisdiction.
But shouldn't it be decided by the single justice?
It may very well, that may be, if the court doesn't want to entertain it, it can be referred back to the single
It's not
justice.
that I
and
don't
then-
want entertainment, I don't know how I can entertainment.
Okay, then I won't argue it. I have tried to brief it if the court wanted to entertain it, or it could be remanded back to the single justice for a decision on that piece, whether or not that particular.
How is it here?
How is it here?
Not here.
It may not be here.
So you can file
It's just-
a no opposition to the motion in the
Well,
single justice?
I'm not sure that I'm not,
She doesn't agree with the outcome.
I don't know exactly what the outcome should be. I think there are arguments on both sides of it. There are arguments for
Kaufman, let me
vacating.
suggest this. There may be arguments on both sides. As a practical matter, is it going to make any difference?
Yes, there's only one way it's going to make a difference. If the bankruptcy court order is vacated,
It is vacated. Oh, you mean, yeah, okay.
I'm not sorry.
If the discipline on,
If the discipline is vacated, and I'm not sure that it should be, because that was a valid order, never appealed. But if it should be decided that that sanction, the year suspension, is vacated, then it's not part of a record in a reinstatement proceeding. In other words, it's not there on the record. It's not one of the things that the panel of the board must consider in determining whether or not Mr. Sheridan should be reinstated.
Let me suggest this. I'm not going to tell Bar Council what to do, but it seems to me that it would be in everybody's interest to wrap everything up. Of course, Bar Council can't consider it, but it seems to me that there's a lengthy record here, even absent that, and there's some ambiguity about whether or not, what the status of that is. I mean, I understand the argument. You've got a valid court order at the time. You don't inform, there's a disciplinary proceeding that flies out of it. I mean, I looked just very quickly at your cases. I don't know what the answer is, but it surely is in nobody's interest to prolong this, to have a hearing before the single justice, which Bar Council seeks to have the sanction not vacated, then we take an appeal from that, then it comes up here. I mean, there are judicial resource issues here as well. So maybe, Bar Council can take all of that into account and figure out whether it makes a real difference to subsequent reinstatement proceedings.
Well, I think if it hadn't been numerous cases involving 88 different violations of the rules, and that the bankruptcy court was so annoyed by the conduct that it actually hired a lawyer to go and prosecute Mr. Sheridan. If it had been
I understand all
smaller
that.
number of events and fewer violations, I think that makes sense. On the other hand, given that all...
I understand. I'm simply suggesting that where Bar Council represents that, the fact of the suspension at least calls into question the viability.
Yes.
You need to think very carefully in terms of the allocation of resources, whether this is, one that should be pursued
Well,
to
it
the
seems-
death.
Yes, and I think also the ball would be in Mr. Sheridan's court, too, because it's actually his motion to vacate.
Oh, well, he makes a motion to vacate, and,
Then we can decide how we were going to respond to it.
yeah.
All right, thank you, Your Honor.
Thank you, Ms. Kaufman.
All right. Hear ye, hear ye.